Hello, everyone. Can you see me? Hello, everyone. Welcome to this webinar. It's going to be an interesting topic that we're going to touch base today about um, living trust and estate planning session. And we're going to have an attorney from San Jose, Tony D. Volo. He's going to be with us today to share very important pointers about um, creating the living trust and estate planning, which is going to be very vital in this situation. So, first of all, I would like to um, have a few pointers shared with you about this session. This is actually going to be a more of an informative session, and this is something that a lot of people overlook due to the priorities that they might have to deal with on a day-to-day basis. So what normally happens um, if you do not have a living trust or a well, uh, the estate planning has been defined in the situations like the difficult situation, something happens to you or your spouse or whoever is part of your family, right? And now more than ever, there are some legal questions that always goes around in the community, and we actually there are a lot of questions not answered to them directly, as people are not much aware of that. And actually, to properly protect yourself, your family, and everything that you have worked so hard so far to keep up with your families, this plays a key role in terms of protecting your families. All right. So before I go into some of the detail, this session we're going to do it in English just to benefit every people who's watching this, and also there will be a more question and answer session happening at the end of the session. And before we go deep diving into the situation and in this particular webinar, I would like to play invocation to Mother Tamil just to give her respects as part of from Kurinji Tamil Manram. I would request everyone to pay respect to. Thank you. All right. So I'm going to present few pointers that's actually in today's life. As long as we are healthy and everything goes smooth in this country, everything looks good and everything is actually going to be beautiful. Life is beautiful, right? And during this corona situation or any other situation, when a person goes through a difficult time, right? Anything could happen to anybody at any point in time. So during that phase, if somebody gets into an accident or whatsoever, right? I'm just talking about an extreme scenario here. We wish everybody stays healthy and live safe in this country and this situation. But I'm just talking about what if scenarios, right? So we have seen some of our friends and families go through this tough time as things happens to them. So if somebody gets into um, or get involved in an accident or they get into hospitals to get treatment, and if there are some situations where the decisions need to be made, and if you do not have a living trust established, right, somebody else is going to make a decision for you, which is going to be devastating. And there are certain things that you would like to have your family members make decisions or a friend of yours make a decision on your behalf. And also going to talk about another area which is very important at this point in time is if a person happens to die without properly executed trust and a will and along with the estate planning, right? Whatever you worked so hard so far, and in order to transform them into your hires, and it costs them tens of thousands of dollars to make that happen. And if you actually, it has to go through a public probate process. And also, like, the second part is like, when a person dies without having this proper trusted will being set or estate planning being done, and California state is going to make a decision without you having any control on that, right? And for the minor kids, and the superior court is going to make a decision whom the kids are going to live with or grow up with. So those are like some of the pointers that really hit me hard when I looked at some of the friends, families struggle and go through this a few years back. I made sure that that's one of my goals that I completed in 2019. So how are we going to get this done, and what are the process to get this done is something that we're going to deep dive in today, and we're going to have Tony presenting us all those information. And also, there's a very important part that I would like to highlight before bringing Tony on board is you have to check with your employer. It's a suggestion and also a recommendation that please do check with your employer. Do they provide you a legal benefit as part of the benefit offering? Majority of the companies in Bay Area, they do provide it, and I have used that feature from my employer, and then I've gone through in creating this trust and estate planning with the nominal fees. It is actually something to be considered, and a new home buyers and young families, who is actually moving into mountain house areas and other areas. No matter where you are, it is very important that this is something that you have to pay attention and get it done as soon as possible. It's going to help you and your family during a difficult situation, which you might not know when someone is going to get into, right? The corona situation has really put in um, everybody into a lot of uncertainty situations, right? And I have seen it myself in our families. People how it's actually a person in my family gone through this coronavirus situation, and I've seen how things have changed from 2 weeks time frame. With that said, I'm going to invite Tony DiVolo. He's from San Jose. Tony, living with the philosophy that attorneys for everyone, right? So charge nominal fees and provide the same quality, attorney services to people around. And he's been doing this service across a lot of Bay Area families and the communities. I have watched this session before that happened around in Bay Area, so now we have privileged to welcome him and have him on board to talk about living trust and estate planning with our community friends. Welcome, Tony.
Thank you, Dinesh. I do appreciate being on the show today. And, that is a very important point that you're making. is I like to explain it in terms of that, yes, we do this because there could be a catastrophic situation. And I always say, thank God you did the trust. You took care of the situation. But I also always say that this trust book will last you your whole lifetime. You know, it's like a passport. You do it, you'll have it your whole life. And yes, in a catastrophic situation, thank God it's done. But I see it as also having organizational benefit. And it's just a way for you to tidy your estate and have it written down on a piece of paper in a book, and it's there in your house for your loved ones. Um, and so I'm going to go through a PowerPoint presentation, and I'll explain who I am and explain what my philosophy is. And then what I do in the basic type of trust seminar is to go through the important points, or at least the areas that everybody has questions about, right? Everybody wants to know about financial assets is one area that's a little tricky. And then the guardianship and successor trustee is the other part that is a little tricky. And then, yes, we'll have questions at the end. You know, I'm kind of a practical lawyer. I make it easy. I don't, like to over indulge and get technical with issues that will never affect your life, or at least very unlikely. So we're going to go through just basic trust mechanics. Let me start the PowerPoint presentation. Okay, so will and trust mechanics. Again, we're going to be focusing on just the basics. And one reason I don't use the term estate planning, because I don't want people to be confused, is that there is no estate tax for most people. You have to have more than $22 million before you're subject to estate tax. And so far, I think I've only had one client that was a concern. Commer went public, and so, but they increased the exemption to the taxes you would pay upon death, which is you've already paid taxes and you die, you got to tax you on all your assets again, but only for people with $22 million or more. So you don't have to worry about planning the estate as long as that exemption stays high. And under Obama, it was 11 million. Trump doubled it. So it doesn't seem like either side of the aisle is going to lower it, but they might. Back in the 90s, it was as little as $1 million. So there's an overarching theme that that even though I do include some provisions to deal with taxes in such an event, we really do have a situation now where we don't have to take drastic measures to try to avoid that tax. Okay. So actually, let me start the slideshow. All right. So again, Tony Bayer de Volo. I'm in San Jose. I'm from California originally. Went to school at Berkeley. I was an economics major. And then I went out to Boston University School of Law, and actually took taxation at Harvard just for corporate tax. And that was back in 1996. So I have been a lawyer for over 20 years, and not a specialist in wills and trusts. Like I say, we're not dealing with complex tax estate planning, which could be very complicated. I do just regular old family trust. I will do an occasional other type of trust, special needs trust. There are some IRA trusts. We won't go into those today, but I do some other basic trusts. I also do corporate law. So any kind of business, I'm a great contact if you have any kind of business. I charge less than most law firms. And I do real estate. I'm a real estate broker. So I have actually a lot of experience in real estate investing, and I can do seminars on that as well. It's a bizarre market in California, to say the least. And so one thing I always have to kind of explain to people is, I only charge $600 for a will and trust package. And I think a lot of people say, that's great. Yeah, I'm not complaining. I don't want to pay more. But they may think, this other lawyer spent $2,500. And I'm sorry for some of you out there who may have already spent $2,000, $3,000 having a trust put together, because it's already done. You've already paid the money. But what I say is that my philosophy is that I do this very efficiently. To me, this is like a product. People go to LegalZoom, and those pre-printed forms that you have to fill out yourself, I'm trying to compete with that market. So rather than be like the other attorneys that I know, I have them in my office where you come in and I have a paralegal and I use a dictaphone, and I just practice law the old-fashioned way. Yeah, I'm going to charge you $2,500, but I have a system down where I do these very efficiently, and I work one-on-one with the client directly, and we just get it done in an efficient manner. And so I only need to charge $600, and it has the benefit that I have lots of other crossover law. So it's kind of a long way of saying that the set of documents I put together are as good as the biggest law firm in the country. But yeah, I just don't charge what they charge, because it's not complicated law that we're doing here. Okay. So what that standard package is, every law firm pretty much does the same thing. You're going to get this trust book. This is an actual trust book, a photo that I took of one of my trust books. And there is the revocable trust, and that is the main document. That's everything. It's also called a living will, because you can think of it like your will. People are familiar with what a will is. A trust is basically your will. But for legal reasons, we do a trust, because a trust, as Dinesh was referring to earlier, is the way you avoid probate. So it's just a weird quirk in the law. It's been this way, predating America. I know in India, you have a will, you register it with the government. Here we have this old-fashioned system where you do a will, it's signed, it's witnessed with two live people, and you have to go to court and say, this is my estate. It's just old-fashioned. So what attorneys started doing was to create a trust that's a contract. It's like in a life insurance policy, like any contract. And it just says, if I pass away, give everything to my spouse. And when she passes away, give everything to my kids. It's a contract and it's enforceable. So since I have a contract, self-executing, I don't need to go to probate. It avoids the entire process. Just like Dinesh was saying, I have an example of a neighbor who was in his 80s, and I said, I would do your trust for free. Your son's helped me out with the yard and some other things. He had no money, and he didn't do it. Some people just have that mental block. And so sure enough, to get the house into his own son's name, who's living there, they had to spend $20,000 and go to court. And if you did the $600 trust, it's all avoided. So, and that's, most people realize at one point they got to get it done, right? But you'd be surprised. I have elderly people that are just getting it done at that time. So we do the trust to avoid probate. Everything's in that document. It says where it goes to your family. And then we also do a pour over will. And just like I said, we don't want to use a will. The whole point of doing this is to avoid having to use a will. But this is meant to last a lifetime. So we make sure that we have a backup document. For whatever reason, there's the will. If we need it, we can go to court. This is a pour over will. So the name implies that if for some reason I had an asset, I have real estate, and I never titled it to the trust, or what happens is that your bank told you when you went to refi, take the property out of the trust because they don't want to look at your trust. They don't want to mess with the trust. They say put it right back in the trust after you refi, and you forget, and it happens. And then there's no property in the trust. So the pour over will says pour over whatever assets I have into the trust. Now you still have to go to court, so we want to avoid that. But the will is there as that backup. Now, a lot of you are familiar with a medical power of attorney. It's important. It's just a state form. It's a California state form, and that's included in the package as well. It just says who your emergency contact information and who is authorized to make decisions if you are unconscious. And it has the organ donation on there as well. And then we do a grant deed, and that is the document that will transfer your property to the trust. So that's included in my $600 package. I do make sure your real estate is put into the trust. That's the most important part. You gotta make sure the house is in the trust by the time you leave my office. We get that taken care of. If you have any additional properties, it is an additional charge, but I only charge $125. Most attorneys charge like $250. So if you have additional real estate, sometimes 2 or 3 investment properties, we would do that as well. And then there's some other forms. There's the assignment of assets. We're going to talk about guardianship, and there's a certificate of trust, and I'm not going to go into those right now. There may be a form or two as well in addition to these. But the point is, you get the whole package. It's a great deal. That's why I've been doing so many, and so many people refer their friends. But I want everybody to have a trust. Everybody in California should have a trust. Okay. So now we're just going to go through some more basic terms, and trust me, this seminar is not going to be too long. I don't like to go on too lengthy. I like to open up for questions. We'll just go through some of the basics. So I feel a need to make people understand that that during your lifetime, you can be called the settlor, the trustee, and the beneficiary. And so if you went, for example, online, you had to fill out your trust information. You are the settlor. You made the trust. It's also known as the grantor, since you're granting it. You're also known as the originator or the trustor. Usually you would fill out the settlor is you. You're also the trustor is another term often used. Now, the trustee is the person in charge of the trust. During your lifetime, that's you. You are the settlor, you are the trustee, you are the beneficiary during your life. The successor trustee is the person that you choose to take care of your estate when both spouses have passed away. So one of the reasons I don't charge much is it's just a discrete document that during your lifetime and the lifetime of your spouse, you could pretty much ignore this. It has no effect. You own everything. I explain it just by saying people are familiar with the will. Here's my will. Please ignore it during my life. Thank you. So you can. It's not a pain to use a trust. It's not anything that has ongoing maintenance. You don't have to do any kind of tax reporting. It's just there, 50 years from now, it will still be valid. It should be a 50-year-old document. But again, if something happened, thank God that you did do this, because it would really make a difference in that unlikely situation. Okay, so now we're going to get to our 2 topics, financial assets and then guardianship and trustee. So the one thing that is a little confusing is that you have these financial assets. And what I try to make every client understand by the time they are finished doing their trust is you do not have to change your trust when you buy or sell assets, right? That would be a pain. We might do that for elderly people. We put their specific asset in there. But when vast majority of people, you don't want to have to amend or update your trust if you open a new E-Trade account. So we say you do not need to amend the trust agreement when you buy or sell assets. The trust says things in general terms. It says all bank accounts, all stocks, all bonds, all vehicles, all real estate. I put everything I can think of in general terms. It says it's in the trust. That's your Schedule A list of assets. And we all do it that way. This is how it's done. Again, makes it real nice. You do your trust, I don't need to change it. You don't need to change it. It should last a lifetime. You might make a change if you have another child, or you want to change the successor trustee, which we'll talk about. Or you, and people when they get elderly will, put in gifts to charities, or I want to give my art collection to my friend. So you may make specific bequests. When the trust is first made, most people just say, give everything to my children, in equal proportions, or however they may want to divide that up. Now, the other thing that's a little confusing, and by the way, this is the standard trust book. I just include a regular 3-ring binder. The nice leather one's an extra $50, but it's recommended. So I have a financial asset, and at the time I opened that E-Trade account, I put down my wife as the payable upon death beneficiary. I put down my kids as maybe a secondary beneficiary, and that works. So the financial institution will write a check to your wife. So you might say, why do I need to transfer my assets, or do I need to transfer my assets? And again, I'm a very practical and straightforward attorney. I tell it to you straight that that you don't necessarily need to do that. It is recommended though. So let me tell you why. There's an organizational benefit to making sure your assets, your financial assets, are in the trust. Remember, a financial asset has a third party holding on to that asset. And they're not going to give away your money without you telling them you have a trust. So it goes back to that payable upon death. You told them who to write a check to, but you never told them you had a trust. You never signed their form. You never gave them a copy of the trust. So they're not going to honor the trust, even if you said, my trust says all financial assets. So you do want to make sure that if you go ahead and transfer the asset to the trust, to fill out their form. Call them up, call customer service. How do I put it in the trust? They'll probably say, go online, log in, fill out this form, and then send us a PDF of the trust. And I always make sure I give you a PDF of the trust. But getting back, just so people say, well, I have all these different accounts. I've opened them. I have my kids listed as the payable upon death beneficiary. I don't know if I'll have time to, get around to it right away. And like I say, they'll write a check to those beneficiaries. When you're in your 90s and your kids are 50 years old, and you may have lots of financial assets, and you may have 2-3 kids, each one of those financial holders, Fidelity, E-Trade, is going to cut a check to each beneficiary. So each child might get 10 different checks. And then they got to pay your final expenses like the mortgage. So there's a real tremendous organizational benefit to say, no, just have all the checks payable to the trustee, and then they put it into the trust bank account. And then the trustee can just go ahead and pay all the expenses, and whatever's left over, they just give to the kids. So it is a little confusing. Like I say, I tell it to you so you understand. You'll probably be fine, but when you have a chance, do transfer those assets to the trust, because it is a much more organized way to do things. And of course, going forward, it's much easier when you do open a bank account or a financial account, some sort of mutual fund. Just go ahead and tell them you have a trust and you're going to open the account in the name of the trust. That's probably about as confusing as it gets. The rest of it's downhill, easy peasy. The financial assets get a little complicated because of what I just went through, but turns out you're probably be okay either way. And that's also why I charge less, right? The main thing we're doing is the real estate that requires probate. You want to avoid that. Financial assets, a lot of times you don't even need to transfer them. Okay, so let's go through some specific assets. Again, nice thing about this particular subject is that it is so simple in many ways. You don't have to do anything with the tax-deferred IRAs or 401ks. It turns out there's a little bit better tax treatment by keeping your tax-deferred IRA, 401k out of the trust. Your heirs, just so you know, will be able to continue the tax-free treatment after death for like 5 years. And so they may not want to close out the account right away. They'll take distributions. So if you keep it out of the trust, you can do that. If it was in the trust, all that happens is that you just have to liquidate the account upon death, which is still tax-free. So you don't have to touch any of those accounts. You do want to do your regular financial investments, like I talked about, good organizational reasons. Checking and savings accounts. Unfortunately, a bank cannot transfer the checking account over. You have to open a new account. So what I recommend is, open a new account. A lot of people have safe deposit boxes, and they won't be able to access that safe deposit box if you haven't put that account in the trust. So your children would show up and they'd be like, give us a court order, get a probate order, or it's, oh no, it's in the trust. So you're the trustee, show me your driver's license, here's the trust agreement, here's the death certificate, you can now access it. See, that's a good example of how trusts work. It's like a trick, you might say. Whoever is the trustee then in office has full access. It's like being the president of a corporation. The corporation exists, and whoever the president is at that time has authority. Same thing with the trust. Whoever happens to be the trustee at the time has authority. And so it just automatically transfers to the successor trustee, who normally is your children. And now they have authority, and the trust says to liquidate the assets and pay out to the kids, and they have the authority to do this. That's just how it works, right? The transfer of the trustee is why it all avoids probate. Now, life insurance is something that you could put in the trust or not. I tell people generally I would leave life insurance alone. You've listed your heir. I mean, that's the whole point of the policy. Yes, it'd be nice if the benefit went into the trust account and you can use that money to pay off all the expenses, but you do have your real estate, which would probably be sufficient to do all that. So generally speaking, you could either way, either you title the asset, title the life insurance policy to the trust, or just leave it as is, naming the beneficiaries. One thing to be clear, because I know it gets a little confusing, is that you can name the trust as the beneficiary of a policy or an account. Don't do that. You can. So there's really 3 ways to do it. You could just put a payable upon death on the account, or a beneficiary on a life insurance policy. You could actually transfer the policy or the account to be titled to the trust. That way the trust owns the account, and whoever the trustee is can, use the money according to the trust. Naming the trust as the beneficiary kind of mixes the two and is possible, but don't get confused. You don't want to put the trust as the beneficiary. It's either use the trust or name your beneficiaries. So I just made that point a little clear. And finally, one thing too that does help tremendously when there are these small little miscellaneous accounts, that the probate court of California does not want you walking in there if you have $150,000 or less. So there is something called a affidavit of small estate. That I get this all the time. Mom never did transfer her savings account, has $25,000 in it. I prepare for $200, give it to the beneficiary. It's just that they have to accept your affidavit, your sworn testimony that my parent passed away and I'm the beneficiary, and here's the death certificate. So you just, we're not going to court, we're not getting a court order. So those small little miscellaneous things, you don't have to then go to court and open up a probate account. So there's this minimum. And all this is in my cover letter, by the way. It's a 5-pager. I put in the book. I sent it to you when we sign up, so you can refer back to it. You don't have to remember everything. Okay, so then the last topic, and I think we're doing pretty good on time. Yeah, is successor trustees and guardians. So a successor trustee is the person in charge of the money. So you have an absolute right to pick who you want. You say, I want my brother to be in charge of the money, both me and my spouse pass away, to take care of my kids' welfare, education, and housing, and whatever else they need. That's something that we put in the trust agreement. It's just who's going to take care of the finances. And the trust agreement obviously says you have to use the money to pay for the beneficiaries. Now, legal guardian is a whole separate thing. It's, who's the person that has actual legal custody of your children? That's a big deal. They enroll them into schools. They, they take them to the DMV to get a license. And of course, they're the ones that are going to physically take custody and raise your children. So, going back to the successor trustee, you want to, if you have minor children, you need to find someone who is that responsible person, brothers, sisters, to be your parents. If you don't have relatives locally, you still should get a friend who could be that person, at least until they could call your relatives overseas, and then they could resign, the friend could resign, and we put as a second and third, or even more, fourth and fifth backups of who would that person be. So your friend says, look, I'm here locally. I realize if there's a catastrophic event, you can't just have the money turned over to somebody back home overseas, because it becomes a foreign trust, and there are tax issues, and it's kind of messy. I mean, think about it. The relative overseas ends up owning all these assets, and they're overseas, so there are tax issues involved. So you might have a local friend realizing that when the dust settles, they would probably resign and then turn it over to the permanent guardians. The other point to remember is that it would be your own grown children, right? When they're like 25, you'd want to amend the trust at that time to make them the executor, if you will, the successor trustee, that they're going to take the assets and sell them for themselves. I do this all the time. Kids in their 50s, right, come back and parent passed away, and so they say, what do we do? And I said, well, your dad did the trust, so just I have a memo on my website. There's a number of memos and letters that talk about different subjects that you would just sell the property and distribute it to your brothers and sisters. So you want to name your kids one day when they're grown, but not until they're 25, I would think. And then find a temporary or local person, at least in America, somewhere that's not overseas. And then also name backups. Who would be the persons that you'll want to make sure that you have backups. And then so getting back to the guardian idea is that you do have your person in charge of the money, but guardian's really tricky because only a court can appoint a legal guardian. So let's say you did put your friend down as the guardian, and then you put a parent or brother, or actually, maybe I should say you put your parent or brother overseas as the guardian. You could already tell how messy it might get. It might be your child is 17 and a half and about ready to go off to college. Well, a court's not going to send them overseas because you said that. You don't really know what's going to be in the best interest of the child at that time. And the standard in court is what is in the best interest of the child. They're going to ask the child. And again, they could be 7 years old. And then, yes, we want to make sure we get a close family relative. So the point I'm trying to make is that you can't legally assign a guardian, although we can legally assign a successor trustee in charge of the money. So a court might say, well, I'm going to have them stay with the neighbor because they're best friends, and it's only 6 months until they're 18, at which time they don't need the guardian. But that doesn't mean we give the neighbor you're in charge of your money, So you've already said, no, it's my brother back home, or it's somebody in charge of my money. But yeah, just trust that the court would make the right decision and who would be the best guardian. Now, yes, you can list people on there. You want to have backups, you want to have contact information. The parties, the courts, they're going to look at, oh, okay, here's all the people, here's all his family members. And the individual wants their brother to be the guardian. So why would we object? Why would the court not do that? They're going to do what you say. As Dinesh was referring to, it's if you don't have anything, they have to start from ground zero. They don't know. They have to call, investigate. Who do we call? So you've already put that in the I give you that document. It has the contact information. You can have 6 people on there. You don't know what the situation might be. So that's the thing with guardians is you want to make sure the court has a list of people to choose from to make sure they do what's in the child's best interest. So my last slide is who do I choose for the guardian? And I guess I talked a little bit about that. Again, yeah. So you don't know who you're going to choose. So you want to put a number of individuals that the court can call up. So that is it for the presentation. And again, I guess my approach to this is, is to make it simple. If it's complicated, I'll let you know. If you wanted to do something that was legally complicated, I would tell you and go over the terms. But a trust is something that just says, give my children these assets. And I joke that it only takes me 28 pages to do that, right? So my agreement, it's only 28 pages to say it's going to go to my kids. But yeah, generally speaking, it's not a difficult concept to understand. I have a very good set of forms. I was very academic, and so I believe, and of course, I've had a lot of elderly people get this done, and I know how it transpires. But you do it, you get it done. You don't ever need to redo it. It's a good price. I tell people, I have clients in their 30s, and they say, if it was $2,500, I'd probably get it done today. But since it is only $600, they do get it done, and it'll last. It lasts your whole life. It's meant to be an ancient document. And their other benefit is that, generally speaking, my approach is I don't like to charge by the hour. If you ever hired a lawyer, every minute they're charging you. So if you had a question, I get people say, hey, I want to form an LLC, or I want to do a franchise, or I have this business. You email me. I don't, charge you. I, of course, charge for work being done, but it's just good. You do your trust with me, then you have a contact as a lawyer. I'm good at referring other specialties. To be kind of a DUI or something, I know how to help you find. So I refer stuff out that I don't do, but like I said, I do the real estate and the business law as well. So anyways, yeah, let's open it up to questions. I guess we went for about half an hour.
Sure. Tony, that was a pretty detailed information. Thank you so much for walking us through with the presentation that you had. A lot of minute details in each of the areas that we have to pay focus on was well covered. And this videos in YouTube Live and in Facebook Live, they will be recorded. People could always go back and listen to it and refer it anytime they would like to do it. That's a good part of this presentation, that what we are doing on a live streaming. You touch on various areas, and I have some preset of questions that came in before we even got into the sessions. I have them documented. I'm going to go through them, and I have one question that came in over the chat for me to ask you, and I will ask that question as well. So I'll be the moderator in going through all the list of questions with you. And before we go into that, the first point that I would like to ask you, so you're charging $600 for completing this process, right? And I called out a pointer earlier before bringing you on, that if an employee have a legal benefit from their employer, right? So which would be higher legal benefit. Most of the employers, that's what they provide to their employees. And it's kind of open enrollment season at this point in time. Majority of the companies would go open enrollment in November, and they finalize everything by December, right? It becomes effective from January 2021. So let's say after watching this session, and friends of mine or anybody around, they go and get the legal benefits from their employer. They open enroll, so they enroll themselves during their open enrollment period, and they come back with a legal plan, the benefit
Yes.
options with them. Would you be able to do the same service what you're offering using that benefit?
Yes, I actually do get that quite a lot. I guess one of the most popular ones is MetLife.
Yep.
And they let you choose any attorney you want. And it's funny, when I first got their first claim form, and you just tell them I want to do a will and trust, can you give me a claim form? And I fill it out. Very short form. That they already have the preset prices that they'll pay. And it turns out they'll pay $650, which is, coincidental is exactly what I charge. So the whole fee's covered. And I guess the insurance figures they pay like $400 for the trust and $200 for a will. And so yes, you'd ask your employer if you have MetLife. They clearly cover it. I haven't personally come across too many other plans. There could be some, I imagine, that say, well, we have a list of attorneys on our plan, but just say, well, I want to use my own attorney. Can I do that? And I think most of them say, oh, well, yeah, you can actually. They may not even realize it. You got to ask them. I don't want to pick one off the list because they're going to cost more. I have to pay the balance. If they don't, I can try to join that. And I'm a solo practitioner, so I haven't tried to join big companies' plans. I think they want bigger law firms, but then they end up paying more. And so MetLife is great. They send the check directly to me. You don't even have to do
Right.
anything. We just complete the trust package.
Awesome. So maybe when people go and put up a claim to start up the process, that's how they go about it. You got to call the insurance provider and tell them you need to do a living trust and a will along with the estate planning. So they say, okay, they open up a claim, then they will send you a list of attorneys within the region where they live around. But actually, you can get back to them and tell, okay, here is my preferred attorney that I would like to work with, right? When you talk about it, and as long as you are in relationship with that insurance provider, they could always accommodate you to have that service provided.
That's right. And I've also had people that that they work at a particular company, and I can't remember which ones, but they say, yeah, they won't. You have to use their list, but you know what, Tony, I'm just going to pay you the $600 because I just like your style, and it's not that much money, and I just rather have that relationship with you. But I think a lot of them they do. They let you pick your own attorney. One thing to remember, guys, too, is that you do pay the notary, you pay the county. So notary is we use. I had last notary I had was like $175, but that was an independent person who I don't know. So typically it should be around $100 for the notary. I mean, it's notarizing all the documents, so you got to pay the notary. And then the county, usually they only charge $30 to file the deed. It is an extra $75 for investment properties. So if you have like two properties, the total cost could be about $1,000, and still great because most attorneys are charging maybe 2,000
Mm.
and with the extra work, and so you're still coming out well ahead. Um,
Okay. Well, if your employer is not offering you the legal benefits, there you go. You have Tony for $600. Now you can get it done, which is going to be very, very helpful to your family and your loved ones. I'm going to go through the list of questions, Tony. So the
okay.
first one I have is, I know you talked about properties like investment properties and the primary property that you're in, right? So what all the property that can go in the living trust?
Well, you really want to put all your property in there, right? Because this is like a will that if I
Right.
die, I want my assets to go, well, it goes to my wife or my spouse, and then I want it to go to my kids. Now, there could be an odd situation where you say, well, no, I own this property with my sister, and if I die, it goes to her. She'll be the 100% owner, and vice versa. But I don't come across that too often. So remember, you want to put all your property in there. It's just that personal property, things like jewelry, gold coin collections, the contents of a safe deposit box, there's no third party holding that, except for the safe deposit box, there's a bank. So unless there's a bank or a financial institution, I don't need to do anything because I've said all jewelry, all art, all personal property is in the trust. So all your household items would be in the trust once we signed it. You just got to remember third party people that hold your assets, you got to let them know.
Okay. And the next question that I have is, what is the benefit of the living trust? And can we just do estate planning without a living trust?
Now, yes, good question because it is a little confusing. Estate planning really is meant to say, I want to avoid death tax. And so it can get incredibly complicated. And you bet people who are very wealthy, I've talked to these New York trust attorneys that it's more complicated than you would think. It's like engineering.
Mm-hmm.
But if you have less than 22 million, again, you don't have to worry about it. And so we don't have to do any planning. Now, like a typical trust like mine will have things in there like a disclaimer trust that gives some mechanism to reduce your estate tax. And also do something called a power of appointment, which CPAs and whatnot can also use if somehow they change that limit and that now you're under the threshold. So I have standard provisions in there to deal with that. But the benefit is to avoid probate and just have a smooth transition, automatic, and not have to have any courts or anything else involved.
So it has to be done together.
Let me get back to your question. So the trust book, the trust documents, it is your estate plan basically.
Okay.
It has provisions in there that, let's say you had you have minor children, and so there's a whole list of provisions how to deal with them. You have a whole list of provisions to deal with co-trustees. You put your wife's brother and your sister, that they would both jointly administer the estate for your children. And so that's like the planning of what we would do. That's why it's 28 pages. There's a lot of detail on how to manage the estate when you have minor children. Once they're grown, then they're just going to take everything for themselves, so you don't have to worry about it too much. But yeah, it's important to have this done in case there was some kind of unlikely event. But just to be clear, unless they change the tax limit, here's something you'll like, that when you pass away, not only are you not paying estate tax, which is pretty bad, you already paid tax, you got to pay capital gains tax, and they're going to tax you on, again. But the benefit is that when people give real estate and other assets through inheritance, the built-in taxable gain that you've built up over your life dies with you, and your children, grown children, literally get the house and they can sell it and they'll pay no tax for capital gains, and there's no estate tax. So they get to keep all the money. I mean, it's most people don't know that, but it's been around forever. It's nothing new. It just makes sense that the heirs don't have to pay the tax of the parents, because the parents may have encumbered the property with debt and you're not really getting much. Yet the taxable gain would be a lot. And so they wipe out any gain. So they get the property out just free and clear.
Sure. And actually, that brings up an important point, right? So normally, when you buy a property, you put a joint tenant, kind of an option, and even one of the spouse pass away, that actually brings the probate process, and the capital gain also comes into picture. The other person needs to pay the taxes if you do not have all these documents. Is that right?
Well, so tax is one thing about a revocable trust, and I like to make it seem as if I'm doing more than I am, but it's also why I do charge less, is that your tax situation shouldn't change because you have a revocable trust. It's kind of a see-through entity. And so, for example, if you have a deed that says joint tenants, one spouse passes, it does go to the other spouse automatically. It's after the second spouse passes away, then you're stuck, right? Then it's like, well, who do we give it to? We think we give it to your kids, but we don't have anything on paper. So you go to court, and maybe you have a will, and it says, give everything to my kids. And the court says, okay, we'll give everything to your kids, $20,000 later. So the deed says it's going from you to you as trustee now. So now the property is being held by the trustee of the trust, which is you, and it's your spouse. And that way it will go to the successor trustee when both parents pass away, and that successor trustee can sell it, sign documents, and then distribute the money to the kids. But either way, the tax situation is the same. And 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 so I won't go into all the details about what happens when the first spouse dies. But there are stuff you should do. You should get an appraisal because you get a step up in tax basis, so you don't pay capital gains. It's a weird situation. What happens is that you get people in their 90s, and if they gave the property to their 60-year-old heir, they would suddenly carry over all that built-in gain that's going to be taxed. And they didn't know. I get this. I said, what? You put your daughter on the title? Don't do that, because now they don't get that tax benefit. So people are waiting until their mother in their 90s passes away because they're going to save all of that. It could be $1 million in taxes. Of course, you could always borrow on the property to get money out. But yeah, it's important that that property passes through inheritance, because then any taxes that are there are forgiven. That they're just they don't carry over to the heir.
Cool. And I would like to go last two questions before we wrap up this session. Um, and we also say that for people who are watching live in YouTube or Facebook, you do have a tiny URL link with a form to fill up. If you'd like to have more discussion about this topic with Tony, you could fill your information. Tony would be happy to set up a separate time, and you can work with Tony if you're interested in doing trust and the estate planning with him. Definitely those list of contacts would definitely help Tony to plan his time and have it scheduled whenever he's available with his next available slot. So last two questions that I have. Normally, people around in Mountain House, they tend to do refinance every 6 months. That's pretty common across our area. I mean, I've done it myself frequently.
Rates are coming down.
Right, rates are going down. You got to make use of that, right? So if I'm struck with one of the revocable trust or irrevocable trust, there are two options, right? So I would like to touch on that pointer as well as what happens if I have a revocable trust and I go into refinance process. What should I do? And is there any fees in kind of associated in doing that transfer in and out? And irrevocable trust, what happens in the situation? So if we can give a little bit of touch around these two pointers, and that will be our last pointer to discuss.
Okay, that's fine. So one way I explain the trust in general is because it is revocable, which means you can cancel it, change it with a single letter, that you haven't really transferred your money. Like if I was to sell you my house and I said it's revocable, they'd be, well, you didn't sell me your house. You can take it back. So that's why trusts are ignored during your lifetime. You haven't done it. It's not final until it's final, right? So that's why there's no taxes. The Code of California literally says a transfer, which is a defined term, because usually a transfer involves all kinds of things, taxes and rights. It says right in the code that a transfer does not include a transfer to a revocable trust. So across the board, you're not transferring anything, as it turns out. And so when it comes to the lender, you have an absolute right, even though your loan says you can't transfer your property without paying off the loan. If we find out, we could call the loan, but not to a trust. So by law, you can transfer to a loan. It does not affect you transfer it to a trust. It does not affect the loan at all. Now, the only reason took me a little while to figure it out, I was like, well, why do banks then tell you to take your property out of the trust when they do a refi? And the answer is that they don't want to look at your trust. It could be an irrevocable trust, like you alluded to. There are all kinds of trusts, and it's a lengthy document. So I understand why a lot of banks say, we have a policy that we don't loan to you as trustee of a trust. Maybe if you were Bill Gates, right? But we're not going to look at your trust. So many people do trust today that half the banks say, yeah, we know you got a revocable trust. So what? We'll go ahead and loan to you, and you don't have to take your property out at all. So what I tell people is try to tell the mortgage person up front, hey, I got a revocable trust. Not that's a big deal, but let's just keep it as is, see if they'll do it. If they say, well, no, we have this policy that says we don't do the trust, then all you do, and the escrow company would do this for you, is you just deed it out of the trust. And then that would be included. And the title company would probably do that as part of the loan docs.
Yep.
Now, when the loan closes, everybody's gone, and so you're stuck holding the bag. I charge $125, just to deed it right back.
Right.
Deeding real estate in and out of the trust is just a non-event. Why? Because it says, it's going from Dinesh to Dinesh. It's you on both sides. So it's just ignored. It just happens to be that you're trustee of a trust. And so it's, very simple. You want to tell them, use my trust. I'll give you a copy of it. I have the PDF. If so, go ahead and take it out. Just remember, call me up and I'll deed it right back. It's going to be the same deed we did originally. And the filing fee, if it's your home, is $30. So very good point, because it shows how it's not just your mortgage, it's everything. It's
right.
During your lifetime, it's the trust is not really changing anything. That's why you can just transfer assets and you don't have to tell your CPA or anything. It's still you. It's just basically ignored.
Cool.
So, and lastly, just because you did bring up irrevocable trust, those are very special instruments. They're used, for example, you might have a special needs trust, or you might, where you irrevocably give money to a brother who is, has a disability and that needs somebody to take care of him. And so I've done those occasionally. They're pretty rare. But you can see how it's irrevocably giving this money to a trustee that doesn't change their benefits because it's being held by a trustee, and the trustee's spending it directly on their welfare, not giving it to them outright, which would then be income. So, but you wouldn't do an irrevocable trust at all. The only time I've had somebody do it was they had a large, I think it was a life insurance policy, and you can do a life insurance trust that really makes that policy outside your estate, because the policy surrender value could be like $100,000 and growing. The policy itself has value to it, and it's a way to protect from creditors that went bankrupt. That policy has been irrevocably given to my minor children, so you can't touch it. An irrevocable trust is a gift of the asset. You say, I can put my house in an irrevocable trust, or I can just give you my house. It has all that same implications for taxes and everything as if I gave somebody an asset, because it's irrevocable. So most people would have no need for that, unless in that one case you have a very large life insurance policy where it has an immediate surrender value and you're worried about bankruptcy or something, which most people aren't. They don't really have that high risk. But it's not that much money to create either. And if it is a sizable policy, then you might hold it that way. I know New York Life is the people I worked with when we did one last year.
Cool.
Yeah, thanks for this presentation. It's been fun. My website, Volo Law, does have articles on there. I try to have the common questions on there that I discuss. And so it's, you can always call me. I pick up the phone personally. I don't have a secretary. I'm very efficient. Talk to every trust package includes that trust overview. So even though you probably won't come to San Jose to sign, I send the book by mail up there with all kinds of pre-printed stickers for instructions, sign here, notarize here. But you're still going to talk to me to go over the trust, and that's part of the $600 fee.
Cool. Thank you so much for your time today in walking us through with all these information, which is so very important information. I have to learn this by watching, other families go through the trouble, right? That actually hit me really hard to say, I have to get this done. So I have to go through this to get it done. I got it done last year, but I'm telling people and sharing with people that, this is something that you don't overlook at it. You have to do it.
That is why I charge less, because there's a lot of people out there who are elderly as well, and they don't get it done. And like you said, lots of stories about I had to go through this, And if it's $600, you have no excuse not to.
Yeah.
It's like two,
This is
$5,000.
this is an investment. You have to think about it that way. This is an investment for you and your family.
Yeah.
So with that, I would like to thank people who are watching live, and please pass on your comments in either YouTube or on Facebook. And you also have a form to fill up to reach out to Tony. We'll share that information with Tony. Tony would be able to reach out to you and have a scheduled time to go over them in detail, and you could talk to him about it. And we will also pass on Tony's contact number in the videos and the other posters that we have, so that you could call him. As Tony said, he will pick up the call and he'll talk to you. Thank you, Tony. Thank you so much for joining us today.
All right.
Right.
Thank you,
Thank you,
guys.
folks.
Let's
We're
put
going to
it
end
here.
this call. Thank you all.